Good morning. Thanks for joining us today on a very rainy day in Southern California. Today's webinar will be doing part 2 of the leave of absence webinar. Last month we covered the medical leave of absence in our webinar, and this month our experts will discuss all other leaves of absence. I'm Denise Ketty, your moderator for this session. A couple quick housekeeping notes before I introduce today's expert panel. We have some feedback going on in the background, so I don't know if the expert panel is not on mute. All right, that's a little bit better. Again, I'm the moderator for the session. Our webinar will run approximately 60 minutes in total. Please take a minute now to download the handouts on your dashboard. If you have questions during the presentation, please post them in the Q&A area on the dashboard anytime during the presentation. If you have a question directed to a specific panelist, you can note that when you send in the question. If we don't get to your questions today, we promise we'll follow up with you. We had a lot of questions after our webinar last time that we followed up with, so don't worry. You can always send the questions in and we'll follow up with you. Just a reminder, today's webinar is being recorded and all accompanying materials are protected by copyright, and our presentation provides general information and doesn't constitute legal advice. The information that is offered is as of today, February 14th, 2019. As always, we recommend you consult with your own legal counsel to address any specific situation and to ensure that you have the most current information on legal matters. Let's get to our panel. Our legal expert today is Marla Merhab Robinson, partner and head of transactional department at Merhab Robinson Jackson & Clarkson. Marla's reputation among her clients and peers is that she delivers personalized service and she is responsive, reliable, and well-respected. There are a lot of law firms in Southern California, but what sets Marla and her entire team apart from other firms is that she and the members of her firm have all worked in the corporate world, so they have a really good understanding of the business challenges and legal concerns your company is confronted with on a daily basis. Our next expert on human capital is Linda Duffy. Linda is the president of Ethos Human Capital Solutions, and Linda and her team are known for building the magic of human connection with their consulting, recruiting, training, and also payroll support programs. The Ethos team works with your company by developing strategies for business leaders to get the right systems, people, and culture in place within your organization so that you as a business owner can focus on running your business and achieving your goals. Linda, can you get us started this morning?
I sure can, Denise. Thanks, and thanks for joining us. I think she mentioned this, and I'm sorry, I was multitasking to get all of the technology going, but there is a handout. So if you look on your dashboard panel, you should see a section of handouts, and we've uploaded a copy of the slides for today. So hopefully you can find that and follow along with us. As Denise already mentioned, we previously covered FMLA, CFRA, pregnancy, FEHA, ADA, and workers' comp. And in case you missed that, because those are obviously all the ones covering most of the big medical issues, you can watch the webinar there. For those of you that don't know, we have a YouTube channel. Marla has one as well. Ours is easy to find. It's youtube.com/ethoshcs. And if you go there, we upload all of our recorded webinars, so you can find them there. So that's what that is, just a short link to that. One of the things that is just so crazy about California is the number of leave laws that employers have to comply with. So I put together this little Wordle just to remind everybody of the other 18 leaves we had last year. And then starting last year, we added a 19th other leave, which is the new parent leave law. So not even considering the leaves we talked about last month, there's 19 other ones that you need to be compliant with. So these are the ones that we're going to run through today. So we're going to talk about those 19 leaves. As always, we're going to save some time at the end and do our best to answer your questions. But before we do all of that, I want to take a quick poll. We are getting ready to launch harassment prevention training, and we're thinking about doing some Google AdWords. And so I'd like your help with this. Hopefully this is showing up on your screen. What this is about is if you were to go out and, excuse me, if you were to go out and actually search for a provider to provide the training that's required under SB 1343. And to be specific, that means all of your managers need to be trained for 2 hours within 6 months of hire promotion, and then every 2 years thereafter. Your non-managers have to be trained for 1 hour within 6 months of hire, and then every 2 years thereafter. If you were to go out and look for a vendor to provide that training, what would you type in to the search engine? So I see people are already jumping on that. If you could just give us some indication of what that is, I would really appreciate that. And we'll just give you another second here to answer that. 50% have voted, so just take another quick second if you haven't logged in already. And I appreciate you giving us some input on that so we know how to structure that. And of course, if anybody needs the harassment training done in their organization, feel free to shoot me an email and we can talk about getting that scheduled for you. So, okay, I'm going to go ahead and close that poll. We have about 70% that voted. So I appreciate that. Thank you very much. And I will just quickly share that poll with you as well, just so you can see see the results of it. All right. So now let's just make sure. Denise, can you just tell me what everybody is seeing there?
We're seeing today's agenda.
Perfect. Okay. All right. Thank you so much for that. And I will go ahead and move this along by turning it over to Marla.
Thank you, Linda. And we're looking forward very much to our sexual harassment prevention training that's going to occur tomorrow in our offices. So yes, it's true, even the lawyers who provide the prevention advice in this area, we have to go through our own training as well. So let's get started since we have a lot of these leaves to cover. Although they're not as technical or as difficult as the ones that went over the last webinar, Leave of Absence 1, they do still address a broad variety of situations and protections that, if not heeded, can result in liability. And these do, many of these do come up often. Others, Linda and I think will point out, we've never had come up even in my 30 years of practice. So the first one is the U.S. military leaves law. For those of you like me who like to know what law it is and where it comes from, this is the Uniformed Services Employment and Reemployment Rights Act of 1994. It's a mouthful. It's found at 38 United States Code Section 4301. And the employers covered are all employers. And if we're dealing with a staffing agency, it's going to be both entities. The eligibility is all employees who enlist in military service or who perform military duties or reserve duties. The qualifying event is enlistment or call to perform duties, and the length of leave available is the time needed up to a statutory maximum of 5 years. However, there are several exceptions for extensions. For example, illness or injury is one of the exceptions that will grant an extension past the 5 years. So if you have someone who is asking for a leave beyond the 5 years, you need to see if they qualify for one of those exceptions or extensions. Reinstatement rights are guaranteed. They can't be waived. And the employee is required to give advance notice when possible. The interesting thing here is that the advance notice can be written or verbal, which always presents a problem for employers with proof of getting that advance notice. Although keep in mind that this type of leave is highly protected, meaning the government is put in all sorts of protections for the employee, so you want to make sure you give it. It's unpaid leave. With respect to benefits, the first 30 days are paid for by the employer, just like any other leave. The COBRA-like benefits kick in after that. There's also a separate statute for veterans that are called back for military duties. Their health coverage can go for an additional 24 months as well. The employer has an obligation with respect to this USERA Act, to abbreviate, So if you don't have a poster up with respect to this, you need to. It can be included, of course, in your other posting requirements. And if you need the poster, please just let us know. You cannot require the employee to use vacation or PTO or sick leave, but you may allow the employee to use it. With respect to holiday pay, it depends on your other leave policies. If you pay holiday pay while someone is on leave, then you must do so here as well. Most employers don't, but I have some that do. Now, of course, California being California, even though we have this very lengthy, very protective United States law, will also always come about and create its own. And this is found in the Military and Veterans Codes, California Code sections 394 to 395, and it prohibits discrimination against any officer, warrant officer, or enlisted member of the military or naval forces. Now, what that means, prohibits discrimination, is it makes it unlawful. It even makes it a criminal unlawful. It's a misdemeanor. The employers covered here, again, are all employers. Employees are eligible who are members of a reserve corps or who have other specified military obligations, including Army, Navy, Marine Corps, Air Force, Coast Guard, Reserves, National Guard, and Commissioned Corps of the Public Health Service. So if you're not sure which branch or a rich military corps, give us a call or give Linda a call and we can tell you whether it is one of the covered ones. The qualifying events are for military training, drills, encampment, naval cruises, special exercises, or similar activities. And the length of leave, unless the federal leave is more, is 17 for private employers and 180 for public. Again, reinstatement rights are guaranteed and advance notice requirements are implied. You also have, under the California Military Leave Law, FEHA protections. California also has spousal military leave under the Military and Veterans Code section 395.10, and this is for employers with 25 or more employees. The eligibility standards are similar, and they've got to be spouses of the Armed Forces, National Guard, or Reserves. The qualified events are a qualified leave for a period of a qualified member, and the length of leave is up to 10 days of leave with reinstatement rights. That the leave is unpaid here as well, and the advance notice requirements are required within 2 days of the spouse receiving notice. The spouse employee must meet 4 criteria: that they are the spouse of a qualified person, they work 20 plus hours per week, they notify the employer within 2 days of receiving notice that the spouse will be on leave for deployment or the intention to take leave, and they must submit written documentation certifying that his or her spouse will be on leave. You cannot retaliate against the spouse, just like the prior laws, and you cannot require use of vacation, PTO, sick leave, or other, but you may allow use of those. It also doesn't affect any FMLA or CFRA rights that may arise if the leave is due to care for injury or illness. The next California law is found under California Labor Code sections 1500 to 1507, and that's the Civil Air Patrol Employment Protection Act. Now, unlike the 3 prior laws, this is one of those ones I've not had arise in my 30 years of practice, but is certainly always possible. It covers employers with 16 or more employees. The employee to be eligible must be a member of the California wing of the U.S. Air Force Civil Air Patrol. Qualifying events would require the employee being directed by a political entity, a governor or the president or Congress, to respond to an emergency operational mission. The leave, again, is up to 10 days. I know it says 10. It's not an automatic 10. It's up to 10. The reinstatement is guaranteed to the same or equivalent position, and as much notice as possible with certification by the proper authority can be required. Again, the same sections prohibit any kind of discrimination or retaliation for requesting or taking this leave. That's something you will see consistent with all the California statutes. Our next one is actually also found in the California Labor Code section 230.3 through 230.4, and it's known as a volunteer civil service leave. It applies to voluntary firefighters, reserve peace officers, and emergency rescue personnel. This may have come up for some of you recently with our California wildfires. We've certainly had a very lengthy fire season, and so we may have had employees that were volunteer firefighters or reserve peace officers or emergency rescue personnel, all of which could have been or would have been deployed for that kind of situation. All employers have certain requirements, and then employers with 50 or more have additional. What's additional for employers with 50 or more employees is that there's an additional, not to exceed 14 days per calendar year for the purpose of engaging in fire and law enforcement training, not just emergencies. There are reinstatement rights here. Again, it's unpaid. Again, you cannot force them to take other paid time off, vacation, PTO, etc., but you may allow it. There's nothing in the statute that addresses the advance notice requirements. The length of leave could be unlimited in emergency situations here. If the authorities have required that it be emergency call, it can be unlimited. Next one is the crime victims leave, and this is found in California Labor Code section 230 sub B and 230.2. And it's actually two types of leave. The first type is where the employee is the actual victim, and it needs to take leave to attend judicial proceedings. And the second is where the employee or the employee's immediate family needs to be at proceedings for any victim at that victim's request. So you also cannot discharge, discriminate against, or retaliate in either of those situations. It's a very broad protection for the employee or the employee's immediate family member who's a victim of a crime. This applies to all employers, and the eligibility is the subpoena or order to appear in court to attend judicial proceedings related to the crime. The qualifying events would be those subpoena or the court order. The length of the court appearance can be, the length of the leave is the length of the court appearance. Understand that it could be more than one court appearance, so that we don't know whether that's hours, days. For those of you who've had the unfortunate circumstance of being in court, you know oftentimes you're sitting there and you don't get heard for days, but you're still required to be there. The reinstatement right protections are there, and advance notice is required where it's feasible, and it's usually feasible because you've received notice from the court by subpoena or court order or police report. In the employees, again, you cannot require them to use a cruise, vacation, personal leave, or sick leave, comp time, etc., but they may use it. You can't stop them. A critical importance here is that you must keep the employee's absence for the stated purpose of the absence confidential. Obviously, we'll know when they're not there. The absences may not be confidential, but the purpose of the absence you must keep confidential. The next one is victims of domestic violence. I always think of this as a new one, and it's really not that new anymore. It's almost 19 years old. This is found in California Labor Code section 230C through D, 230.1. And there's, again, two types here. One's leave for legal proceedings and one's leave for medical treatment if the employer has 25 or more employees. The eligibility standards are just a qualifying event, which would be an event of domestic violence. It prohibits discrimination, again, or discharge or retaliation of an employee who's a victim of domestic violence from taking time off from work to appear in court due to subpoena, or also for medical treatment if it's 25 or more employees, if it's an employer with 25 or more employees. Also, FMLA and CFRA may come into play here, so we have to keep that in mind. The length of leave available is the time necessary to resolve issues, and the reinstatement rights are available again. There may also be reasonable accommodation issues that come up here with FEHA, so we need to make sure that we are having that discussion. Advance notice is only required when feasible. Again, it is unpaid, and you cannot prohibit them from using vacation, but you can't require them to. This is another, I beg your pardon, this is another one that you must keep the reason for the absence confidential. Victims of sexual assault, this is found in California Labor Code sections 230C through D and 230.1. Basically, the rules are the same as those of the victims of domestic violence. And of course, we're seeing a lot more of this as the Me Too movement comes into play and employees are more comfortable coming forward and discussing this. Victims of stalking, this is found in California Labor Code sections 230C through D and 230.1 as well. So you can see these are similar because they're all found in the same sections. Generally, the rules are generally the same as for victims of domestic violence and victims of sexual assault. And then we come to my favorite. This one does come up quite a bit. It's not my favorite because I love alcohol. It's my favorite because it does come up quite a bit. And because it's one of those statutes that leaves a lot of traps for employers because it's not specific. It's very broad in its prohibition of an employer discriminating against an employee who wants to enter or who has voluntarily entered into a rehab program. The statute is written so that the employer must assist the employee, but it doesn't really say what that assistance is. It's been held that it doesn't mean pay for the rehab, so that's good news. This applies to employers with 25 or more employees, so not small employers. The employee must have enrolled in the rehab program and it must have been voluntary, and the employee must not be currently using at work alcohol or drugs at work, and the length of time for the leave is whatever time is necessary for the rehab that doesn't cause undue hardship for the employer. So we have an analysis we have to do there, because this is another statute that provides a reasonable accommodation unless there's an undue hardship. The plaintiffs' attorneys love these types of statutes because we can argue all day long what's reasonable with respect to this leave accommodation, 10 days, 30 days, 60 days. And then what's an undue hardship? Well, it's going to cost me X dollars or Y dollars. There's no black and white answer here. It's just an argument and then the facts that support the argument. So the employees' attorneys bar, they love these types of statutes because there's always an argument one way or the other. The employee, again, can use sick leave or any of the other available leaves. And you also have FMLA, CFRA, or FEHA applicability here that we need to look at as well. And also timing of which one of those would come first. And with that, I'm going to turn it over to Linda.
Thanks, Marla. You are cracking me and Denise up, if nobody else, because yes, you do love a good Chardonnay.
I do.
Thanks for all of those leaves. I'm going to start talking about a leave that's near and dear to my heart for different reasons. And that is, there's a couple different leaves here that I put on the same slide, which is the organ and bone marrow donation. Not too long ago, this actually came into play for personal reasons because a friend of mine needed a kidney. Now a second friend of mine needs a kidney, and no, neither one drink. But this is a law that allows employees to actually be paid while they take time off to donate an organ or bone marrow. In fact, these are the only leaves in California that I'm aware of that requires any payment from the employer. Now, in both of these cases, employees are covered if they're working for a company that has 15 or more employees. I believe they have to be employed for 90 days before they're eligible, but they can take up to 30 business days, not calendar days, but 30 business days per year if they're donating an organ and 5 business days if they're donating bone marrow. You can require them to provide certification, other things like that. And you can require them to use up to 2 weeks of earned sick or vacation or PTO leave if they're going to donate an organ, and up to 5 days for bone marrow. But if they don't have that, or if the need for the leave goes beyond that, then the company is responsible for paying their salary while they're gone, also keeping all of their benefits in place. They are entitled to be reinstated. And as I mentioned, you can the employee can be required to provide verification of being a donor and the medical necessity of doing so. Any time off that's taken does not count against FMLA or CFRA either. So this is just carved out very specifically under the Michelle Macon Memorial Donation Protection Act. And if you want to look that up, it's Labor Code sections 1508 through 1513. All right, let's talk about sick leave a little bit. So for sick leave, this has been on the books for a while, so hopefully everybody is providing sick leave if you're in California to your employees. We want to touch on a few different things. So this is required for all employers now, and we see a couple of mistakes that go on, so we wanted to sort of highlight those. So pretty much all employees, are going to be eligible for this. There are some requirements like working, for the same employer in California for at least 30 days, things like that. And there's a long list of qualifying events. The length of leave available, though, is where we see some problems. There's a minimum of 3 days or 24 hours, but whichever is greater. So, for example, we have a client, we have several of them actually, but we have a manufacturing client that is on a 440 work week, meaning their manufacturing personnel work 4 10-hour days a week. The minimum number of hours then they have to give their manufacturing employees is 3 days at 10 hours a day, so that would be 30 hours of time. So you want to just make sure that you're compliant with that. There's a few different ways that you can provide the actual leave accrual, or you could front load it. So, the state says, okay, you have to have enough time available by day 120. There's options to do that. The one that they originally proposed, there were two basically, but the original proposal was to accrue a minimum of 1 hour of sick leave for every 30 hours of work. Well, of course, no payroll system can look across multiple pay periods. And so we all said, okay, we're just going to do the math and set up the accrual differently. But as time has gone on, it's become clear that the accrual, whether it's that accrual or different accrual, could have a problem. Their accrual also says that you have to allow the accrual up to 48 hours, even though you can limit usage to 24 hours in a year. But, try explaining to an employee why the pay stub shows 40 hours of available time or 48 hours of available time, but they can't use it. So for now, what we do, and I know Marla feels the same way on this, we just suggest really strongly to our clients to front load the time when the person comes on board. And then whether you want to wipe that out and reset it on a calendar year basis or on an anniversary, a higher anniversary, whichever way you do it, just make sure that you're complying with the minimum number of hours provided and that you're complying with those accrual limits or accrual rules as well. Because the other mistake we see a lot is people say, well, I have my own plan, and that's fine. You can have your own accrual. But for example, I have clients who say, well, I'm going to give people 5 days off a year, 40 hours. And they're going to start accruing it from the time they start. Great. But if you look at 40 hours and divide that over 12 months, you won't meet this minimum accrual by the end of the 4th month or 120 days. So you want to make sure you always look at that as well. So if you have any questions on that, just reach out to me or Marla and we can help you with that. The other thing you want to pay attention to is the reinstatement rights and advance notice rights, because what's happening is we have employees who may miss a lot of time, for example, and then the employer wants to go write them up for that, which they should, right? But the problem is the state has said if you take any action against people for using a protective leave, which is how they view sick leave or protected leave, that they're going to consider that retaliation against the employee. So what we advise our clients to do is just sort of ignore these first 3 days and let employees take their time, and then look at it in a bigger picture, right? To say, okay, let's take a look at how much overall time they've missed, but carve out those 3 days and just assume that those 3 days are protected. Okay. New parent leave law. This is actually, out of all the laws that we're talking about today, the newest of the leaves, I think. This went into effect, I think it was January 1st, 2018. This is a little bit interesting because employers with 50 or more employees within a 75-mile radius are covered under FMLA and CFRA for the birth, adoption, or foster care placement of a child. So this actually dropped it down in California for employers with 20 or more employees. What's interesting to me is that it says if an employee is not covered under FMLA or CFRA, then they're eligible for this. So you could have a situation, as one of our clients does, where they're headquartered here in Irvine. They have a few hundred employees, so they're subject to FMLA and CFRA, but they have some satellite offices. So if they have an office in Fresno, for example, that has 25 employees, the employees in Fresno are actually eligible for this leave, but not for FMLA or CFRA. The employees in Irvine are eligible for FMLA or CFRA, but not for the new parent leave law. So you want to make sure you're looking at both of those if you have multiple offices and see, like when you write your handbook, do you need to include both FMLA and new parent leave law, or are you only going to be subject to one or the other? This allows for time off to bond with a new child. The time off has to be taken within 1 year of the child's birth, adoption, or foster care placement, and the employee is entitled to reinstatement rights. And of course, we would assume that advanced notice can be required. There's also a provision in this leave that says if both parents work for the same employer, then you can restrict the combined time off to be a total of 12 weeks in that first year. And you can also require the employee to take it in separate 2-week blocks, so as long as it's within a year. So sometimes they want to take it intermittently, but you can require at least 2-week blocks. You have to continue your insurance coverage for the 12 weeks as you normally would. So for example, if somebody is making payments or contributions toward their premiums, you can require them to continue to do so, just like with most of the leaves we talked about in the last webinar. And then also, if an employee is given time off under this leave, then they can apply for 6 weeks of paid family leave time payment, I should say. And that's something that we wanted to also just raise. We didn't really talk about this last month too much, and this comes up a lot for us. The paid family leave, a lot of people think that provides time off. It doesn't provide time off. It provides pay if the employee has time off. So what I always instruct my clients to do is when you're thinking about leaves of absence, to separate the two issues, time off versus pay. So the first question is whether the employee is eligible for time off under whether it's your company policy or any leaves of any type. And so you look at that first, and then you figure out how much time is this person allowed to take off, right? And that could be a discretionary leave, or discretionary medical leave, or it could be subject to a federal or state leave. And after you take care of the time off, then you ask yourself and the employee, okay, are there any other financial resources to support you while you're taking that time off? Maybe it's state disability or workers' comp if it's an injury or illness. Do they have vacation, sick, or PTO time they can take? Is there paid family leave as for the birth, adoption, or placement of a child? But separate those two things off as you're thinking about them. And also, we just wanted to let you know for sure that the paid family leave, we wish they had titled it something else, but it does not grant any time off. So we just wanted to make sure everybody was clear on that. All right, time off to vote. This is something that comes up every once in a while because a lot of employees have a little bit of knowledge it's a dangerous thing, right? So they hear from a friend, oh, you know what, we get 2 hours off to vote. And that's not what the law says. So this is Elections Code section 14,000 to 14,002. And it says if the employee cannot vote, during the polls, which in California are open 7 a.m. to 8 p.m. So I don't know anyone who pretty much couldn't vote there during that time frame. But if they could not vote during that time frame, then they must be given time off to vote, right? And it's up to 2 hours. And the time must be paid for the first 2 hours. So maybe somebody has to travel out of the area or something like that, but they need to give you notice. You also have a posting requirement to give them notice at least 10 days in advance before a statewide election, and it must remain posted until the election itself. So this doesn't come up a lot because most employees are not working 13 hours a day, but just be aware that it could be a situation where you need to give them some additional time off and actually might have to pay them if they need more than 2 hours. Okay, jury duty. Obviously, this applies to all employers. We want everyone to do their civic duty, and also if they get a subpoena to appear as a juror. So we've all gotten that letter before. We all have to go down there. You can require them, obviously, to provide proof that they got subpoenaed to actually go. And in theory, you need to give them whatever the length of jury duty is. Now, most employees try to get out of this because they don't want to serve, and also they don't want to go without pay. You are not required to pay the employees. There's no direction on the use of PTO or vacation and sick, whether you can require it or not. So don't require them to use it, but most of the time we would allow them to use it. You cannot discharge, discriminate against, or retaliate against anyone for using their rights under this law. And you also want to remember that if it's an exempt employee who does any work during the week, you're going to want to pay them their full salary. So that's where we do have some issues come up where the employee goes to jury duty, but they're sitting there during a break or while they're waiting to get called, and they're answering emails on their phone, or they're taking calls from a client, or they brought their laptop to get some work done. So even though you wouldn't technically have to pay them to serve jury duty time, if it's an exempt employee, then you're going to want to make sure if they're doing any work that you continue to pay them. Witness duty is very similar to that. Same sort of rules apply. This is in California Labor Code Section 230, Subpart B. You cannot discharge, discriminate against, or retaliate against anyone for using this leave as well. And again, there's no advisement on the no advisement on the use of PTO. So typically what we would advise is, allow people to use it if they want to, but don't require the use of it. Okay, we have visited school authority. So there's a couple of different laws covering the right for employees to take time off to go to school. So this one is specific to if a child has been suspended or disciplined in some manner, and you need to go meet with a school authority. Then usually it's going to be just a few hours or something, but you are allowed to take time off to go and do that. So you're not paid for that time. Again, you can allow employees to use their vacation time if that's what you want to do, but you cannot, again, discipline or discharge them for taking time off to go take care of this problem at school. And this is under Labor Code Section 230.7. Similarly, the Family School Partnership Act, this applies to employers that have 25 or more employees at the same location, so it's a little bit bigger, where the other one didn't have a minimum employee count. And this was expanded a few years ago under Section 230.8 of the Labor Code to allow employees to take time off up to 8 hours per month and 40 hours per year to go deal with school things. And it could be, you want to find a school for them, or even a childcare provider for them, a licensed childcare provider, or you could also go to school for different events and things like that. So this one, you can require the employee to use vacation or PTO to the extent that the employer wants them to do so, and of course you can always give them the ability to do that, and you can require the employee to provide documentation, of their need to go to the school. And if both employees or both parents work for the same employer, you can limit it to so only one of them can go at a time. And then we have the employee literacy. I need it apparently. Literacy Education Assistance Act. Sort of like Marla referenced in one of her leaves before. Never in 30 years have I ever had an employee take advantage of this leave. It's California Labor Code Sections 1040 through 1044, and it basically requires employers to reasonably accommodate and assist any employee who says they have a problem with literacy and they need some help with that, so they want to enroll in an adult literacy education program. While that's great, I don't know how many employees are going to take time off without pay to go get help with this. You do have a requirement to keep illiteracy confidential, and you cannot terminate an employee for illiteracy if they're actually satisfactorily performing their duties. So Again, I've never had anybody take use of this, but it's out there in case somebody needs it. A couple of leaves that are not statutorily mandated, we just wanted to mention to you. So bereavement is a leave that we often write into handbooks. You're not required to offer bereavement, but some of the issues you might want to think about if you are going to have a bereavement policy is who qualifies for the leave, whose deaths are covered. You know, is it immediate family? How do you define immediate family? How much time off are you going to provide people, and is it going to be paid or unpaid? Are you going to pay for the first couple of days? But beyond that, they take, you know, PTO, things like that. Are you going to require proof of death? It's a really touchy subject. I have some clients that say, well, I want to know because maybe they don't trust that employee or this is the third time it's happened. I tell my clients that bereavement is one of those things that does not happen all that frequently. It does happen, but it's also usually a time we want to support our employees, whether it's unpaid or paid leave. So just think through all of those issues about who qualifies for the leave and under what circumstances. And you can pretty much structure it however you want to, as long as it's on a non-discriminatory basis. Same with personal leave. You're not required to offer discretionary personal leave or discretionary medical leave. We typically suggest to our clients that they write those in, because even if it's for a company who's subject for FMLA or CFRA, as an example, what happens if during the first year of employment, you know, the employee gets into a car accident and needs a month off, requires surgery of some kind? You know, if it's a valued employee, you probably want to support that. So you're going to want to have some sort of discretionary medical leave. A discretionary personal leave might be for things like, you know, they need to fly out of the country for a period of time, and it's before they have enough vacation time accrued or something like that, or need to take care of a sick parent and they're not yet eligible for, you know, FMLA or CFRA, if you're subject to that. Or maybe you're just not subject to that at all, and so you want to offer something similar to your employees. Again, you can pretty much set the rules for that. You don't have to offer anything, but if you do want to offer it, think about under what circumstances can they request the leave. Is it medical only? Is it for personal reasons? What type of reasons? How long are you willing to give them? What will their reinstatement rights be? You know, are you going to protect the leave, not protect the leave? Are you going to agree to put them back into the same job, a similar job, make no comment about it, whatever you want to do? And then how will the leave affect their benefits? If you're going to give them, you know, some sort of extended time off that is not a statutory requirement, then how is it going to affect the benefits? Are you going to keep them for the first 30 days, for example, and after that they go on COBRA? Are you going to just continue to cover them for whatever period of time? You know, so think about all of these issues, paid, unpaid, how is it going to affect their benefits? And then also, again, who's eligible? For example, under bereavement leave, what if it's a domestic partner's family, things like that. So think about all of that. And also what we would really strongly urge you to do is take a look forward and also take a look back. I think I mentioned this in prior webinars. You want to make sure, even though your intent is never to discriminate, and you look forward and you go, yes, we're going to have this great policy, and we're going to give people discretionary personal leaves, right, under certain circumstances. But then a year later, you look back at all of those discretionary personal leaves, and then you see an unfortunate pattern that you only granted them to white employees, or you only granted them to men, or something like that. So you always want to be looking in both directions to make sure that even if it was not your intent to discriminate, the end result was non-discriminatory as well, and then just adjust the policy accordingly. And then finally, before we take some questions, just penalties for non-compliance. There's a whole bunch of penalties built in. They're different for each of the different types of leaves that we talked about before. Most of them do have prohibition against retaliation against employees who want to take the leave, but it can be things like, you know, reimbursement for lost wages and benefits, civil actions, administrative remedies, reinstatement to a job, things like that. There's some leaves that have like treble damages written into the penalty section. So you want to make sure that you understand all the leaves that your company is responsible to provide. Take a look at the posting requirements and other notice requirements, and making sure that you're getting those to your employees as well, especially those people that don't have a handbook. It's doubly important that you take care of it in another way. So if you need any help with that, of course, just reach out to us. With that, I'm going to turn it back over to Denise and see if we have any questions.
Thanks. Thanks, Linda and Marla. I will say I've read some of these laws, and they're so complicated, so to have you break them down really is helpful. We do have a couple questions. We're going to start with a couple for Marla. If you have a situation where you find someone is using drugs, can you still give them leave, or can you just fire them?
That's a great question because it comes up often. As I said, that was one of my favorites of the leaves because it does come up often. And if they're actually using, and you discover that they're using, you can terminate them. I've had a lot of employers say, I don't want to terminate this employee. He or she is a good employee. You know, I want to help this employee. You can sit them down and say, we want to assist, we want to accommodate you into going to a rehab program. You've got to sign up for a rehab program, provide proof that you're in a rehab program, which they can usually do because these rehab programs are very much aware of the statute that protects the employee. And if you successfully complete the rehab program, most of which are 30, 60 to 90 days, depending on the severity of the problem, then, you know, we'll just have you out on leave and you'll come back. If you don't, then we're going to terminate you. So they don't terminate even when they do discover that there's current use. The current use is not protected unless the employee comes before the employer discovers and terminates and asks for the accommodation. And I want to apologize to everybody on the call. I don't know why we're having such technical difficulties today with all the background noise, but maybe it's the rain because it's really bad out there.
Thanks, Marla. There's another question for you, Marla. In the beginning of the presentation, you mentioned unpaid leaves, and we have someone who wants to confirm that assault, stalking, and rehab leaves are unpaid.
Yes, they're unpaid. However, I have lots of employers who will pay for these types of leaves for a certain period of time. There's nothing that prohibits an employer from paying for leave, even if they're not required to do so. And sometimes they have, times that they'll say, okay, we'll pay for this much leave. And sometimes what that does is it encourages the employee to come back.
And Denise, I would add to that also just the general reminder that I mentioned about exempt versus non-exempt employees, because a lot of time on those type of leaves, it might be, I need 4 hours to go meet with somebody. I need, to take an appointment on Thursday afternoon, and it's just a partial day. And so again, if you have exempt employees and they're doing work during that week, you want to continue to pay their salary. If it's non-exempt employees, then you can just pay them for the time they actually worked.
Linda's absolutely right. She's absolutely right. That's a great qualification. If there's any work being done by that exempt employee, you're going to want to pay them.
That's a good point. Because as we all know, people are taking phone calls and emails if they're exempt at all times. There is another question that came in, and I don't know if this is something that you guys can answer specifically or if it's something that may have to be taken offline. So how do you answer whether or not an exempt employee under an unlimited vacation policy should be paid while on leave, given that the vacation doesn't accrue?
So timely question, because Marla and I actually were just talking about that this week. So all I can do is tell you what I'm doing for my own company and tell you what I've seen other companies do. So at Ethos, we have an unlimited time off policy for exempt employees. But the way that I wrote it was that if they are eligible for a leave, once they become eligible for a leave, so if usually after a week or so, then there's a period of time for which I'll continue to pay them, and then it steps down as time goes on. So for example, off the top of my head, I don't remember exactly, but it's something like, there's a 1 week waiting period where disability doesn't kick in, as an example. I'll pay them for that. I'll make up the difference between their SDI and their regular pay for like a month, I think, and then after that, it drops off, okay? So you can do a step down like that. Marla, I know, has some concerns about unlimited policies in general. So Marla, you might want to talk about that for a second.
Yes, and it is funny because Lynn and I literally were just talking about this Tuesday morning during our prep for this webinar, because the law is not clear here, and so whenever the law is not clear, I have to always advise my clients there's risk. Linda has definitely reduced the risk by putting in those step downs, because that could be an argument that if the DLSE said no, you really are accruing, but it would at least tell you how much that maximum accrual would be. So I would just encourage anyone who wants to look into unlimited time off that you contact either Linda or our firm or another employment counsel firm, not general corporate firm, but employment counsel firm, and craft your policy very well and address. Kudos to the person who asked this question, because you want to address these other leaves as well, because you could put into your policy, for example, this unlimited paid time off will apply for this list of leaves up to X number of days. So, or it doesn't apply at all. We won't pay for that because it's not required to be paid for that. So you just want to make sure that you get some assistance with it and understand what your risks are in using an unlimited time off policy, which, by the way, seems to be growing in leaps and bounds with most tech companies.
Right, and that's what my experience has been also, mostly with tech companies, where that's very common practice for them. But I do think whoever asked the question is spot on, that the biggest issue is what happens if they go out on a leave. For what period of time are they going to be paid? And also take a look at, other company policies that you have to make sure that everything's in agreement. Also look at your employee benefits, right? Your other benefits. Is there a short-term disability policy that you have, or a long-term disability policy that the company provides? Because you want to dovetail all those things together. When I was head of HR at a tech company a number of years ago, we had a very generous benefit program. And so we basically paid exempt employees, I think, up to 90 days or something like that of sick pay, because we sort of look at it as like being like self-insured almost. If they had ongoing problems getting their work done, then we might take some sort of disciplinary action or work them out of the company if we couldn't turn that around. But we paid them for about 90 days. And then at that point, there was a long-term disability program that kicked in. And so that's what kicked in at that point and took over the payments. So just take a look at all those policies.
Yeah, I'm with you on the tech companies. I've seen a lot of tech companies do that also. Since we're talking about minimum paid time and sick time off, is there, and I think you covered this, Linda, but maybe could you just cover it one more second? What is the minimum paid time for sick leave?
So the minimum is 24 hours or 3 days, whichever is greater. So if you've got employees that are working a regular 40-hour work week, 5 8-hour days, then it's going to be 24 hours because that's 3 times 8. The tricky part comes in if they're working an alternative work week. So we've got clients, for example, that we put in an alternative work week for them with the state of working 4 10-hour days. Well, then it's a minimum of 3 days times 10, which is 30 hours, right? So that's the minimum. The other thing I should mention, because we get this question a lot, is what about my part-time employees? There is no provision in this law to prorate the sick pay. So sometimes if I've got a client that has a lot of part-time employees, that's about the only circumstances under which I ever suggest that they consider whether or not they want to do the accrual. I still try to steer them away, but that's the only time where it makes sense, where there might be a break even in favor of doing the accrual, because you still have to provide 24 hours. So you could have somebody that only works a few hours. Well, I've got an employee like this. We just call her, periodically when needed. She's a second recruiter. So, I thought about it and thought, okay, I can set this up as an accrual, or I can set this up to front load the 24 hours. I don't want to deal with the accrual. So I just front loaded the 24 hours. Not sure when she's ever going to take it. She's not scheduled that much, but it's there if she needs it. There might come a time where we need her, more on a full-time basis for a short period of time. She'd have the sick pay available. So that's the only time I even think about it. But otherwise, just front load it with 3 days or 24 hours, whichever is greater.
It's probably better safe than sorry.
Without a doubt.
We have a couple more questions, and I'm going to try to get to them before we have to close. So back to the new parent leave law. That's, I believe you said it was the newest law in the books. Can
Yes.
you require that the leave under the new parent leave be taken in 2-week blocks versus a day here and there, or longer than 2 weeks at a time? So you mentioned that you could cut up the leave in different ways. Can you have it taken in 2-day blocks? Can they do it a day here or there, or can you make them do it longer?
I would have to go double check that to give you a very specific answer on that. And if you just Google new parent leave, you'll find it. There's a handout for it, I think, on one of the websites. But my notes, all I can do is tell you right now, my notes say that you can require it to be in 2-week blocks. So some leaves can be taken intermittently, in hour form, and I believe this one you can require 2 weeks blocks. But whoever has that question, if you shoot me an email, I'll look at it for you.
Okay. And another question on the parent leave. You mentioned that that you have to be with the company you have to have 12 months of service. Does that mean you have to have 12 months of service when either the day you adopt a child or have the child, or just 12 months of service when you go to take your leave?
Yeah, so that's interesting because in theory you could adopt the child and then later become eligible for the leave. Unless Marlon knows something different, I believe that the person would be eligible once they've hit the 1-year mark and the 1,250 hours of service, right? So let's just say you started working on January 1st, you adopted baby in September, right? And then you become eligible on January 1st the next year for the leave. You would still have another 9 months, from the time you adopted the baby, right, to be able to take that leave. Marla, do you have any reason to believe that's not the case?
Well, I'm not sure I'm understanding either one of you. You have to have had at least 12 months service and at least 1,250 hours of service prior to commencing the leave. So you could be asking for it later.
If the child was born, adopted, or placed prior to you becoming eligible, you would still be eligible at the point of time that you hit your eligibility requirements, even though the baby came before you were eligible.
Correct.
Right. So between September and the end of the year, in my scenario, you wouldn't be eligible, right? But then January, when you hit your 1-year mark, you would become eligible, and you would still have another 9 months of time remaining in the year since the baby was placed with you or adopted to take the leave.
Okay. Good.
I'm rolling with that answer.
Yeah. I know we have 1 or 2 other questions that I think are going to be too long to get into with our limited time, so we'll make sure that we swing back around with you at the end of this. Linda, do you want to go into what next month we have in store?
Yeah, so Marla and I always try to come up with something we think will be of value to everybody. And we've been seeing a lot of wage and hour and payroll mistakes lately. And so that's what we're going to do on March 21st is talk about the biggest wage and hour mistakes that we see. You'll see here the link to register. And of course, we'll be sending that out to you later this month as well in a second email. So if you have any questions regarding leaves of absence, then by all means, reach out to one of us. And hopefully you can also register for next month's leave at the same time. Anything else, Denise?
Perfect. No, I was just going to say perfect. Thanks, everybody, for joining us today on your rainy Valentine's Day in Southern California.
Thank you, everyone.
Thanks. Bye-bye.